Bob. And I'm glad you could read my notes for that introduction. Good morning, everybody. A colleague at another school recently told me that when he walks into an audience and he says good morning in an MBA class, often he'll get a rousing good morning from the class. When he walks into a PhD class and he says good morning, the students usually put down their heads and they write down what he says. When he walks into an executive group and says good morning, often somebody in the back of the room will sort of sit back in their chair and they'll say, well, not in my experience. Sort of nice to get the MBA rousing good morning from you all. I want to thank Bob for inviting me to this presentation. It's a thrill to be associated with POS. POS has really become one of the jewels in the crown at the Ross Business School. I want to thank Janet Max for her great work in setting up the logistics, and a special thanks to Paul and Diane Jones. We had a delightful conversation this morning. I really loved getting to know you, and they are the ones who have funded this fantastic series, and really appreciate what you've done for the school, so thank you. Let me start with my final slide, and I hope that you'll be thinking about these questions as I do my presentation. Does the proactive law model make sense? I would appreciate it if you would attack me as much as possible. I love disconfirming evidence, and I really love to be attacked, just so it's not a personal attack. And then second, is there any synergy? Do you see any synergy between proactive law and the work of POS? Because I've admired POS from afar, but I have a feeling that there's more we could be doing together. This is my game plan. I'm going to talk about law as a source of competitive advantage, which is a U.S. movement, and then we'll look at what's been happening in Europe. I'll run you through an example involving product liability, and then talk about some current research that relates to proactive contracting. Then I'll put you to work. We'll do a couple of exercises, one related to workers' compensation and one relating to dispute resolution. And then I want to close by noting how this work might relate to values creation. So just a quick warning, the first two bullets are going to be pretty boring, but I've got to bring you up to date. I've got to lay the foundation, and then I think the interest will build as your pizza continues to digest. So that's our game plan. So let's start with law as a source of competitive advantage. I really started thinking about this years ago when Bob and I taught in a 4-week executive program together. And he got to walk into class, and he did a lot of research. He surveyed hundreds of executives. And he figured out that these were the goals of these executives. And so he got to walk into class and talk about all these positive things, develop a lot of energy. And then I got to follow him in class, and this was my agenda. How do you reduce workers' comp costs? How do you prevent product liability claims? How do you comply with government regulation? How do you avoid wrongful termination lawsuits? I got sort of depressed following Bob. He got to do the fun stuff, and I got to do the risk control, what was perceived as negative stuff. In fact, over the years, I'll often ask executives, when somebody mentions law and lawyers and regulation and the legal system, how many of you feel sort of a warm glow welling up in your chest? And, the number is minimal. Instead, they sort of viewed law as a burden or an obstacle. And so I started to emphasize, well, I don't agree entirely, but even if that's true, the companies that best address this burden or obstacle are going to be most successful. So really my thinking on this topic developed several years ago, and I wanted to try to turn the thinking of managers and executives upside down because I thought they were missing a great opportunity to create value. And as it turned out, about the time I was thinking about some of these issues, other people around the country also had started to think about these issues, and they started to look at these questions. So, for instance, Robert Byrd at Connecticut looked at law as a viable source of sustainable competitive advantage. He used Jay Barney's resource attribute framework and looked at how law fit into that framework. And then there was Connie Bagley from Yale, who focused on the public policy objectives of the law and how, if managers understand these public policy objectives and became what she called legally astute, then they would increase their chances for business success. These are, if you're interested, one of her best books is called Winning Legally. It's a Harvard Business School publication. And then Richard Schell of Wharton had a more specific focus. His focus was on the public policy process and how business can achieve success by, in effect, establishing the rules that lead to its success by influencing the public policy process. And then my contribution was more focused on daily business operations and decision making. I felt the other people were flying at 50,000 feet, and I wanted to try to bring this closer to the earth. And so I started by looking at the work of some of the other people with a little bit of a critical eye. For instance, Richard Schell's emphasis on public policy. I think it's fantastic if businesses become involved in influencing the public policy process. I take students to Washington, D.C. every year through the Carson Scholar Program, and we look at how process is influenced, how the system works. However, I think that businesses have to keep in mind that if they invest a lot of time and energy and money in influencing the public policy process, they're benefiting not only their own business, but they're benefiting their competitors as well. For the most part, there's a big free rider problem. And so question as to how strong of a sustainable competitive advantage influencing the public policy process creates. And then another aspect of competitive advantage concerned me, and that's the impact of comparative advantage on competitive advantage opportunities. Some people, and this popped up in some of the other research, were advocating going to jurisdictions where, let's say, the law was friendlier and regulatory costs were lower than in the United States. And I was very critical of this approach for a few reasons. First of all, we live in a global economy, and so we have huge cross-border movements of products, services, and investments. And so it isn't going to help your business if you move to, let's say, China, and you're exporting to the United States, because you're going to be directly impacted by the U.S. legal system when you sell your products and services in the U.S., when you make investments in the U.S. But then the other factor is that law itself has converged so that when you look around the world, the laws have become very similar, and even legal process, which used to be a real differentiator between the U.S. and elsewhere, has become much more similar than in the past. So, for instance, with contract law, we have the Convention on Contracts for the International Sale of Goods, which is a huge step forward because we have now a uniform international law governing the sale of products. Environmental law has become very similar from country to country. Insider trading law, developed in the U.S. now, is an international standard. Same with sexual harassment, bribery, and I'll be returning to product liability later. Even when it comes to legal process and these unique factors of the U.S. legal system, there has been convergence. For example, the jury trial used to be a distinguishing factor in the United States. The jury trial is virtually dead in the United States. According to recent studies, only 1.2% of federal cases go to trial. And at the state court level, it's half that. It's 0.6% actually go to trial. Punitive damages, the court system and the legislatures have developed rules that constrain the amount of punitive damages that are awarded today. There have been changes in the so-called American rule governing allocation of legal costs. Contingency fees and class actions have been exported to other countries. Countries like Canada, United Kingdom, China, Japan, Australia have moved toward class actions and contingency fees. Same with discovery. There have been liberalization of discovery processes. So bottom line, this notion that there are certain comparative advantages associated with the legal system has diminished because of this convergence. So after criticizing these elements, then the question is, well, where do you go? And the starting point, and this isn't new, this is old, is for a manager to gain competitive advantages to start with legal literacy. That's what Bagley of Yale has emphasized, and given a strong public policy background to that literacy. And second, as a manager, you're going to do what businesses have done historically. You have no choice to react to legal problems once they develop. Unfortunately, often this is through litigation. And in litigation, you've got the classic response developed in the plains of Savannah, where you either fight, you go to court, or the flight option, which is where you settle. Early in my career, I actually did some work in how businesses can react in a more logical way. And so, for instance, I tried to apply decision tree analysis to settlement decisions and show how this is a very valuable tool for linking together various issues, for calculating expected values, but also for making resource decisions. Decisions such as where should I focus my discovery? Should I focus my discovery on a copyright validity issue, determining similarity, access questions, and in deciding how much to pay expert witnesses? That kind of logistical question is also aided by decision tree analysis. Beyond that, though, I thought that law should become much more strategic, and especially in two regards. First of all, there should be a focus on preventing future legal disputes. In a fast-paced business world, business people, like everyone else, often don't have time to reflect on experience. The research shows that this isn't law, this is in general. We spend 87% of our time making decisions and only 13% of our time reflecting and improving. But number one, once you finish litigation or once you address a legal problem, very important to reflect on it and try to prevent future disputes. But then, and that's what leading companies do. If you look at best practices, it's focused on the preventive dimension. But then I argued that we should take this a step further and try to reframe legal issues as business issues. And I know that doesn't mean much right now, but I'll give you some examples as we go through the presentation. So this is where I wanted to focus, to try to bring law a little bit closer to earth than was done with some of the higher level research. Now, as I was doing this, I discovered that there was something very similar going on in Europe called the proactive law movement. This is the definition of proactive law. In addition to avoiding disputes, litigation, and other hazards, proactive law seeks ways to use the law to create value, strengthen relationships, and manage risks. The proactive law movement began in 1998, strangely enough, at an American conference. Helena Hapio presented a paper at the ASQC Congress, or ASQ Congress, and this eventually led to the development of something called the Nordic School of Proactive Law, which is a network of researchers and practitioners from Scandinavia. And then also the creation of a proactive think tank, which is a broader network of researchers throughout Europe. And this is sort of a summary of the PLM approach. We need to move beyond reactive ex post approaches to law. There's a preventive dimension that focuses on collaboration between managers and the law function, what they called a promotive dimension. The goal is to embed legal knowledge and skills in client strategy and everyday action. And this builds on regulatory focus theory. Some of you might be familiar with some of that work coming out of Columbia. So those are the key concepts. And there were a number of papers, and the first book came out and finished, Ex Ante, Proactive Law, in 2005. And here's another look at what they do. Rather than focusing on risks, problems, and losses, you should also focus on opportunities, desired outcomes, and benefits. Rather than focusing on failure and avoidance, the traditional legal approach, let's focus on success. Rather than focusing on preventing negative effects, focus on promoting positive effects. Rather than focusing on rules, legal tools, look at goals, processes, practices, and understanding. And rather than being driven by lawyers, this should be done through cross-professional teams and through collaboration. Now, the PLM movement in Europe struck a tremendous home run a couple of years later, when the European Economic and Social Committee, which advises EU institutions, adopted an opinion, and it's called the Proactive Law Approach, a further step toward better regulation at the EU level. It recommends that European Union institutions and member states adopt the proactive philosophy in developing the law. This is a copy of the opinion with a reference. Anyone's interested, I'll be glad to share these slides later. But basically, they concluded that this approach should be considered systematically in all lawmaking and implementation within the European Union by making this approach a priority for legislators and administrators. At the EU, national, and regional levels, it would be possible to build a strong legal foundation for individuals and businesses to prosper. And the conclusion was the proactive law. Oh, wait a minute. The recommendation then was that the Commission, the Council, and the European Parliament adopt the proactive approach when planning, drawing up, revising, and implementing law, and encourage member states also to do so whenever appropriate. So this has become embedded now, this proactive law approach, in European regulation. So I met the leader of the proactive law movement around 2007, Helena Hapio, at a conference. And we began to compare notes, and we realized that there was a huge overlap between what was going on in Europe and what I was advocating. And you can see the comparison. It's largely a difference in semantics. We both thought that legal literacy was critical for managers. We both recognized that we'll never get rid of the reactive approach. A lot of businesses still are going to react to legal problems rather than acting strategically. I emphasized a strategic approach called prevention. They called it a proactive approach. I emphasized going beyond prevention and using reframing to change legal issues to business issues, and they called this a promotive element. But there's a lot of similarity between the two. This diagram sort of summarizes where you go once you move beyond the reactive approach to a preventive or a promotive or reframing approach. On this diagram, I've changed that language a little bit. I'm going to call it the positive approach in honor of POS. We haven't really used that language much. But for now, I really like positive better because reframing and promotive are a little bit distant or vague. And what we're really talking about is a positive approach to the law. You can sort of use a medical analogy here. If you develop malaria, you react by going to the emergency room. That's the traditional reactive function of the law. You develop a legal problem, and you go to lawyers, you go to the court system. Instead of waiting to develop malaria, you can take a preventive approach. You can take pills. You can use netting to keep out mosquitoes. That's the preventive approach. Or you can be more proactive or positive. You can, for instance, drain the swamps where the mosquitoes are breeding and eliminate the cause of the problem, and in so doing, perhaps benefit the community in other ways. So that's sort of a medical analogy of where they were headed in Europe and where I was headed with my research in the United States. By the way, Helena sent me this email, August 9, 2009. Hi, George. I recently encountered a research orientation known as the Positive Organizational Scholarship, which seems to resonate well with our proactive approach. Surprise, surprise, it all seems to have started and be currently located at your business school. Do you happen to know any of the people? What a small world. Well, boy, was I able to impress her when I said, guess what? My next door neighbor is Jane Dutton. And down the hall is Kim Cameron and Gretchen Spreitzer. And around the corner is Bob Quinn. Wow. And I could really drop some names there. So, what this illustrates is a tremendous impact. Here we have this researcher in Finland who, law-oriented, but learns about the great work you all are doing. So Helena and I basically tried to merge our two approaches in a book called Proactive Law for Managers, A Hidden Source of Competitive Advantage. It came out last year. This was a lot of fun and challenging because we were coming from different orientations. We had to merge our orientations, but we were also coming from different continents. And frankly, I never realized how U.S.-centric I was. I thought I was pretty global in my examples, but she challenged me every step of the way, so we were able to hammer out a true global orientation to proactive law. And even though the book just came out last year, it's beginning to have an impact. It's used as a framework for courses in the U.S. and European business schools, and the European Commission has funded an Erasmus project, quote, to develop core curricula on proactive management and proactive business law, and to develop the concept of proactive law. And those materials are now just coming out. I saw a huge packet of student materials and then instructional materials. And it's, as a researcher, frankly, often you're ignored, but it's fun to have this kind of an impact. This morning I got an email from a teacher in the Netherlands. And he said, I'm using your book as a model for my course. And, when he sent me a copy of his study guide. And this is exactly the kind of impact that I was hoping our work would have. This is what he wants from his students. You can describe the main legal aspects of HR, production, marketing, finance, strategy. You'll understand the theoretical knowledge underlying proactive law. You'll understand the use, the function, and the objective of law to improve corporate strategy and introduce changes. Understand the use of regulation as a source of competitive advantage. Understand how contracts and contract management are used to improve business and prevent problems. Learn how businesses can use tools and legal resources to achieve competitive advantage. That's what we want students to leave courses with, and that's beginning to happen. I even discovered that a business has taken our approach and developed a game. If I can get, and I saw a copy of their promotional visit video.
Lawyers are trained to understand, manage, and remedy all problems. Once they understand the facts that are relevant to the law, they think like lawyers and will help you solve these problems. But what if we do not have problems or risks? Would you hire a lawyer? What if you could use the law as a competitive advantage? What will you do? Proactivia, the game, is a business simulation which is about how to create success, new opportunities, and adding business value, all from a legal perspective. Can you make connections between strategy, contracting, and business results? Will you use a proactive approach? Proactivia, the game. Be one step ahead.
So I haven't actually seen the game. I've just seen the teaser, so I'm not sure if it's anything I should mention or not. But at least we're now into gaming a little bit. So that's the background. Let's take an example. One of the more difficult issues facing American business over the last few decades is product liability. This is just one piece of product liability. When you look at asbestos litigation, according to a RAND report, over 6,000 companies have been named as defendants. 75 out of 83 types of industries, 90% of U.S. industries have been affected by just this one piece of product liability. We spent a total of $54 billion on asbestos litigation. Estimates are that this is going to run to $200 to $265 billion. And this results in reduced investment by defendants and reduced number of jobs created. So huge impact in just this one area. And, of course, it affects the auto industry, pharmaceuticals, et cetera, et cetera. Okay. In terms of legal literacy, as probably most of you know, the two foundation areas of the law affecting business are contracts and torts. And in a product liability case, there's going to be a contract theory based on warranty, and then two tort theories are going to come into play, strict liability and negligence. And again, I realize most of you are already aware of this. Strict liability was really a game changer in manufacturing because courts, beginning with California and then spreading through the U.S. and the rest of the world, decided that to win a case, a plaintiff no longer had to prove that the manufacturer was at fault. With strict liability, if you produce a product and the product injures someone without proof of fault, the manufacturer is liable. It doesn't make any difference how careful the manufacturing process was. It doesn't make any difference if you're at the Six Sigma level. You're still liable under the theory of strict liability. I apologize for this. This is a little bit racy, but one of my MBA students, executive MBA students, sent me this example of a complaint, and this is what businesses receive daily, and it illustrates the three theories that arise. This was a case involving a Los Angeles police officer who bought a Victoria's Secret undergarment called Sexy Little Thing, a low-rise V-string. And she was putting it on. There was a piece of metal that snapped off, hit her in the eye, and injured her eye. So now she's suing Victoria's Secret, and it's the classic product liability case. Count number one, strict liability, in the way the company manufactured the product, designed the components, and sold the product. Number two, negligence. We got the two tort theories. And then number three, breach of warranty. So, classic case. Those three theories are going to hit every manufacturer. So, of course, when you get that knock on the door and they deliver the complaint to you, you've got to react through litigation. And you might use a decision tree type analysis to help you decide what to do next. But the question is, what can you do from a preventive standpoint, first of all? And then, are there any opportunities to move beyond current best practices and think in a more positive light about product liability. That's a real tough one for people in business to think, product liability, positive. Because the two usually don't go together. But from a preventive perspective, these are the big issues. First of all, the ultimate strategic question is, do you drop the product or do you make or sell the product? A survey of CEOs indicated that 47% of their companies have decided to drop products or not manufacture them because of the impact of product liability. The only question I have about those decisions is, are they acting with legal literacy? Because too often, I think they're asking the wrong question. They're asking, if we manufacture this product, will we become liable in a product liability lawsuit? And that indicates a lack of understanding of product liability law, because the principle of strict liability is based on the assumption that the manufacturer is simply a conduit to pass liability on to you and I as consumers. And we each pay some little fraction of a penny toward the damage awards through price increases. That's at least the theory of the way product liability should work. And so the real question shouldn't be, will we as manufacturers be held liable? The real question should be, are we in a position so that we can pass the costs on to consumers? So you've got probably the hugest settlement in legal history. The tobacco companies settled litigation for, they agreed to pay $208 billion. And you think, that's got to wipe out tobacco companies. They did not miss a step because they were able to raise the price of their products. They raised the price of a pack of cigarettes by 76 cents. Under the settlement, they also agreed to lower their advertising costs, so they saved some money there. And they were just as profitable as ever because they were dealing with a very inelastic market, too. They were dealing with smokers, addicts. And so they were able to pass on the costs. Now, I'm not advocating that you get into the tobacco business, but what I am advocating is legal literacy. Understand, move beyond the knee-jerk question, will we be held liable? The real question is, can we pass on the costs? And then once you decide to make or sell a product, another preventive, very important preventive question is, what kind of organizational structure should we use? You and I are very familiar with what the president of Columbia University once called the most important discovery in history, even more important than electricity, and that was limited liability. When you and I invest in a company, the most we can lose is our investment in the company if the company goes under. They can't take our personal assets. If GM goes into bankruptcy and you're a GM shareholder, they can't take your car and your house, et cetera. Well, this same principle, of course, applies when the corporation is a shareholder. We call that a parent corporation. And so as a preventive measure, what companies can do, and they often do, they set up subsidiaries. They are shareholders in the subsidiary. The subsidiary creates what lawyers call a corporate veil that protects the parent from liability. And so, for instance, we had a case involving a world-class race car driver named Mark Donahue, who was killed in a race using Goodyear tires. The tires are made by the English subsidiary of Goodyear. He wanted to pierce the veil of the subsidiary and go after the parent. Normally, the subsidiary would have protected the parent. However, when a parent dominates and controls the subsidiary so that you can't separate the two, then courts will pierce the veil and hold the parent liable. So I don't want to get too deeply into the law here. There are other reasons for piercing the veil. The important thing is this illustrates the importance of collaboration between legally literate managers and lawyers. Lawyers will do a great job in setting up the subsidiary. You're the ones who has to run it. You're the ones who are familiar with the way it's capitalized, how assets are transferred, whether the parent is involved in new product development, etc. And ultimately, how much control the parent has over the subsidiary. So this collaboration that the proactive law movement has emphasized is illustrated by this preventive law tactic. Another piece and the final piece of preventive law relates more directly to operations and sales. Just a very simple, let's do just a real simple simulation relating to product liability prevention. Let's say that we're all sitting here as the product safety review team for our company, okay? And I am a new product manager. I bring to you a new product proposal. It's a hairdryer, basically like many others, except it's a talking hairdryer, let's say. Okay, what is the first question you as a manager want to ask when you're reviewing the safety of that product? Where do you start? We're all sitting here, product safety review team. Is it what? Is it grounded? Okay. Before you get to that, you're jumping a little bit ahead. Very important first question. And I'll warn you in advance, if any of you have an engineering background, this is going to be a very tough question for you. Does it go on or off? Okay, that's a good question. But even before we get to that question. Okay, we're getting warmer. Alyssa? Yes. How are hair dryers used? Now, this drives engineers nuts. They say, well, we designed it. It's designed to dry your hair, of course. How else would you use a hair dryer? How else might you use a hair dryer? Can you give me any examples? Okay, dry your skates, dry the perspiration. How else? Yeah. Dry glue. How else?
Blow up some kinds of furniture that you get at IKEA that are like balloons.
Blow up your IKEA furniture. How else? Dry film. Or shrink wrap. How else do you use hair dryers? Dry your cat. No, you're supposed to use your microwave for that. Okay, so, the problem here is we've got a highly educated, bright group. If I ask the same question to a normal person, then they would come up with 15 or 20 reasons. But, a legally literate manager understands that the question is not how is this product intended to be used. The question is, what is a reasonably foreseeable use, because you've got to design a product that is safe for the uses that people actually make of the product. And so, and again, this is very tough for engineers. They've got tunnel vision. This is the way the product is supposed to be used. And so what you need is normal people rather than engineers. So these are some of the reasons that pop up when I do this simulation with executives. But then what do you do after you've identified those uses? Test it. Are there risks connected with it? Yeah, you identify the risks. And then what do you do after you've identified risks? Warn people. Wrong answer. And I get this all the time from managers who aren't legally literate. That does not count if you can design out the risk. So first of all, you've got to try to design out the risk. So you identify foreseeable uses, you identify the risks, you redesign the product, and then you develop, and then, Shirley, you're right, then you develop warnings. You're not entirely wrong, but it's the sequence. So, for instance, this case where you've got a Goodyear tire, it's got a huge warning in red and yellow, includes a drawing showing somebody being thrown into the air when the tire explodes. Never mount a 16-inch size diameter tire on a 16.5 rim. This can cause severe injury or death. Well, somebody read that warning, tried to mount a 16-inch tire on a 16.5-inch rim, was blown away, suffered severe brain damage, if he didn't already have it, and sued Goodyear and won $5 million. Why? Because other companies had figured out a way to design out this risk. You've got to design first before you start slapping on warnings. Now, admittedly, warnings are going a little bit too far nowadays. You've probably seen some of these ridiculous warnings. Do not use orally on a toilet bowl cleaning brush. Twist off with hands. Throw top away. Do not put top in mouth, the label of a bottle drink. Warning has been found to cause cancer in laboratory mice on a bottle of rat poison. For indoor or outdoor use only, on a string of Christmas lights. I'm not sure where else you would use them, but wearing this garment does not enable you to fly on a child-sized Superman costume. Beware, to touch these wires is instant death. Anyone found doing so will be prosecuted. A sign at a railroad station, do not attempt to stop the blade with your hand, and a manual for a Swedish chainsaw. Warning, I see this all the time when I fly. Warning, may contain nuts on a package of peanuts. So, we've gone overboard on warnings. But, this illustrates the kind of preventive tactics a legally literate manager can use. And when I deal with managers and executives, sometimes they go ballistic about this point, about this stage. They say, why do we have to design our products for idiots? Why do we have to develop warnings for idiots? Well, I sympathize to a certain extent with them, but then when you try to take a more positive perspective, what are these idiots telling you when they are saying, we're using our hairdryer for these purposes? What are they telling you? We need products to do these things. We have to use our hairdryers for these purposes because we don't have products. So what you're getting here is free consumer research on what your customers want. The legendary CEO of GM put it this way: to discuss consumer research as a functional activity is erroneous. In its broad implications, it's an operating philosophy which, to be fully effective, must extend through all phases of the business, including the law function, and serve the customer in ways the customer wants to be served. Where you're getting this laid to you on a plate, this is the way the customer wants to be served. They're giving you these examples of foreseeable uses of our product. So that's the product liability example. My current research, one piece of the research deals with workplace bullying. And I don't know, again, if there are any intersections with POS here. Let me ask you this question. Let's say we've got a manager who harasses the men and women who report to him, harasses them severely on a daily basis. Is that legal in the United States for this person? Would this person be liable for harassment? How many would say yes, there is liability for harassing employees? How many would say no, no liability? Okay, and so we have about 1/3 yes, 1/3 no, and 1/3 not voting. It depends. Okay, it actually doesn't depend. Absolutely no liability for this type of harassment. Now, if you harass on the basis of sex, race, religion, a protected category, yes. But there's no liability for being a workplace bully in the United States. So in my research, Well, in my research, I'm doing a comparative study, going around the world. What I'm discovering is we're surrounded by countries that do make it illegal. And a tsunami is on its way to the United States. Once we adopt the new laws following other countries, companies are going to be hammered. They should be developing policies now. And so what I'm doing, going around the world, trying to gather as many case studies as I can, trying to translate those. If any of you can translate Japanese, French, Italian, etc., please let me know, because it's very expensive to do this. But I want to try to help companies be prepared and develop appropriate policies. So that's that research. The second one, I'm sort of calling corporate conversations. Over the last... Janet, do we have to 1 o'clock?
Oh, yeah.
Okay, I just wanted... Okay, good. We're in good shape. Over the past decade or so, as the use of email began and increased, in many corporate cases, email has been introduced as evidence. And this is a treasure trove of information about the conversations that go on within a company. It used to be around the water cooler. Now they're via email. And I'm trying to gather these conversations, organize them, and then the basic goal here is to get companies more oriented toward educating employees about their values and about the content of their conversations, rather than focusing on what they call their document retention systems. A better name is document destruction systems, where they try to destroy the evidence. Why not focus on the creation of these documents? But to do that, they need case studies. They need examples and policies. So that's the focus of that research. And then the final one, proactive contracting. I'll explain that in just a little more detail. And this is actually an example of where the two prongs of the strategy can conflict. With the preventive approach, the goal of virtually every business today is to develop a so-called perfect contract, an agreement that is final, binding, and enforceable, and the contract documents need to be as legally perfect as possible. Now, what does legally perfect mean? Well, it's got a heavy dose of risk allocation and risk orientation. This is a major study conducted by the International Association of Contract and Commercial Management. And they actually do this every year. And every year the results are the same. This is the focus of contract negotiation, issues such as limiting liability, indemnification, intellectual property liability, protecting confidential information. It's heavily risk-oriented, heavily legalistic. But your preventive approach would say, well, that's what you need to do. You need to prevent liability. You need to protect yourself. What's wrong with what's going on across America or even the world as we speak? Well, what's wrong is what used to be a handshake deal has morphed into contracts that are 40, 50, 60 pages long. What's wrong is the transaction costs, the time and expense of working with lawyers when you draft the contract initially, develop these 40-page contracts, and then when business issues arise, you've got to go back to the lawyers and say, what does this mean? They double dip. And the contract, what's wrong is the contract becomes the focus of future disagreements rather than business problem solving. The business managers involved say, well, what are our rights under the contract? If you didn't have this huge accumulation of legalese, they would go face to face and try to work out a business resolution. What's wrong is that when you're negotiating cross-culturally in other countries, there's a big problem when you take the more U.S.-centric approach, which is toward longer contracts, and you're negotiating in a country where relationships are more important. What's wrong is that this approach focuses on negatives rather than on positive business opportunities. This is from an IACCM publication. Risk allocation and avoidance continue to dominate interactions during the negotiation of formal business-to-business agreements. So this is what's sort of driving my research in this domain. And I think there's a conflict between the preventive strategy, developing legally perfect contracts, and a positive approach which would focus on business goals. What I've discovered is there's a little tiny pocket of lawyers in Scotland, of all places, that has the opposite extreme. I guess it must deal with Scottish notions of thrift. People of few words. So their approach is that contracts should emphasize free market economics rather than legalities. And they have a minimalist approach. This is all you need in your contract. What are you selling? And what's the price? You need something to protect intellectual property rights. And all the other terms can be implied by law. You don't have to try to incorporate every possible contingency and make this a 40 or 50-page contract. This is a paragraph from one of their contracts. We therefore agreed on the essentials of our contract. Rather than wasting time and expense negotiating and recording and writing other non-essential terms, we have agreed to allow the general law to regulate such matters, implying such terms as it may. They build heavily on this notion of commercial affinity, which I've added my own definition, which is a post-agreement BATNA. Those of you who are familiar with negotiation are familiar with the notion the best alternative to a negotiated agreement. Well, this is sort of a philosophy that says your BATNA never ends. After you negotiate and sign the contract, it'll continue because you can walk away to your best alternative at any time, based on this notion that commercial affinity really keeps people together. It's a desire by each party to continue doing business because it makes sense. If they can't satisfy each other's needs, they just walk away from the relationship. So the contract says, for instance, there's no minimum duration for this agreement. We'll simply continue to do business with each other for as long as it remains mutually beneficial to do so. Bottom line is, this is just a contract I picked out as a contract between Coors and Rocky Mountain Bottle Company supply agreement, 23 pages plus many pages of exhibits. This is the Scottish contract, 1 page and 1 attachment. Now, that sounds great, but I think there's a middle ground here. As you know, Scottish law is governed by the civil law system, which has some fundamental differences affecting the way you negotiate agreements. What I want to find out is, can we start with the Scottish approach, and then what would we have to add given the legal environment in a common law country like ours? I think we can still come up with something a lot better than these 40 or 50 page or more contracts that just aren't focused on business objectives. For instance, I think that the shorter contracts work better in a long-term supplier relationship rather than a one-term snapshot transaction. And one thing I want to get into is the role of trust. I don't know if any people in POS deal much with trust issues, but I think trust should be an important element of reducing the legalities. You've got this example, Buffett decides to buy a company from Walmart. Usually, this transaction is going to cost millions of dollars and months of time for legal due diligence. Here, it was a 2-hour meeting and a handshake. And why? Because he trusted Walmart. We did no due diligence. We knew everything would be exactly as they said it would be, and it was. Well, I don't know the body of trust research, but I'd like to learn more about it, how this might impact trying to shrink contracts and develop leaner contracts. Okay, let me give you a quick exercise. I think we're pretty much on time. Janet, and do people have, if anybody needs paper, let us know. Okay? I'm sure you're all familiar with the fundamentals of the workers' comp system. The basic notion of workers' comp is you get automatic compensation and medical coverage for on-the-job injuries, and the trade-off is the worker cannot sue the company. You know, that's legal literacy 101. Workers' comp, you know, sometimes it reaches crisis proportions. Other times it's more in a valley. I just pulled this from the governor's website in California. In the past 2 years, the cost of workers' comp has risen from $14.8 billion to $19 billion, estimated 12.6% increase. And they just passed some new legislation to address that. But the bottom line, workers' comp goes directly to your bottom line. And so if you have higher workers' comp costs than your competitor, you're going to be at a disadvantage. And so my question for you is this. Your company has experienced much higher workers' comp costs than your leading competitor. What are your top 5 preventive or proactive recommendations? Remember, our 2 branches, our 2 strategic branches, preventive approach, proactive approach. Just talk with others at your table. I'll give you 5 minutes or so. We won't take forever. Think of 5 or so recommendations that you would make given this workers' comp problem that you have. Okay? Good luck. Let's stop and just to keep things moving. And did you 2 work together? Can you give us one of your recommendations?
Identify the problem and remove or reduce the injuries and the type of injuries.
Identify data collection, identify the problem, and reduce. Great example. Can you give me one?
Safety program, communication and training.
Safety program with communication and training. Great. Incentives for reporting and suggestions. Fantastic. This table, can you give me one? Just one. Competitive intelligence, sneak into the competitor's plant. Okay. Yes. Okay, good. Anything new at this table that we haven't mentioned? Great ideas. Partner with the insurance company. They probably have a lot of experience with a broad range of companies. Good idea. Idea here?
Yeah, we came up with a number of things like design safe programs, design safe processes, ergonomic chairs and things to deal with things like back pain, toxicity levels, if there are any standards, legal standards from just studying healthy workplaces.
Fantastic. Yeah, that's a big, you know, cumulative injury and fatigue. Those are huge, big issues. Okay. Somebody works on the plant line, develop appropriate exercise regimens. Any new ones here?
Instead of going after the problems, murderers and so forth, they started arresting guys who washed the window who didn't want it, people who urinated on the street. And the notion was if there's a broken window in the factory one day, the next day they're all broken. The signal is no one cares.
Okay.
When you start to care for the system, all this behavior changes.
Okay.
So what if we said we're going to dramatically improve the culture of our company around caring for people?
Okay.
Respect them, whatever it is, that you don't go after the root cause, you go after this bigger message that we really care about safety and so forth.
Okay. We care about workplace safety, and that's part of the embedded in the culture. Okay. And I didn't get to this, did I? Anything else beyond the others?
We talked about having the system monitor and buy into the process.
Great. Did I get every table? Okay. If I had to summarize the results, I think although I want to get back to this broken window. I think, basically you're talking, well, you didn't get into hiring very much, the way you screen and place workers, but data collection, corrective action, and you also didn't get into what happens after an injury. One of the big issues in workers' comp, you send the worker home, there's no communication, you feel bad, you think that worker's shirking, the worker feels bad because that worker thinks you don't care, and the worker's sitting at home watching late night TV, and the lawyer's advertising, oh, you got a workers' comp claim? So, communicate and get them back on the job, even in a limited capacity. So, very good preventive frame. I wonder about the positive frame. For instance, what would you do in this case? I had a plant manager in one of my, in the manufacturing executive program. She manages a plant in Iowa, and many of her workers call in sick during the first week of deer hunting season. Because of absentee in the plant, she almost has to close down the plant. So what do? You're this plant manager. What do? Close down the plant. Okay. Anything else apart from close down the plant? Or reschedule, so you can pick up production in other ways.
See a small example of creating responsibility, cultural responsibility.
By
Some small example, like I was saying, that how are we responsible? How do we reinforce responsibility in the plant?
Okay. What would you do? Give me.
Somebody that didn't like how I left. Somebody that did the little things that
Okay.
made a difference.
You have a responsibility to show up on the job, among other things. This is what she did. She started a hunter safety program because, people get injured hunting. And she realized, you look at workers' comp through a legal lens. You think, on-the-job injuries. Where do most injuries occur? Off the job. This relates a little bit to the broken window philosophy. Focus on the bigger picture, because that worker who's injured off the job while hunting creates just as much decline in productivity and hiring and retraining, all the other issues, as the worker injured on the job. Or here's another example. This one, I don't have the answer to this. This just came across my transom 2 days ago. But you walk into work and you notice one of your employees has bruises covering her arms, swollen lip, discolored cheek, and other signs of domestic violence. And let's assume that you correctly assume this is a case of domestic violence. What do you do as a manager? The important thing here, I think, all you had great preventive approaches, but the important thing is to think more broadly. U.S. workers are actually safer on the job than at home. Future lost production time resulting from off-the-job injuries is 12 times what's lost from workplace injuries. So, think more positively. This article I read on domestic violence, written by a lawyer, says this. Domestic violence, first of all, is a huge cost in lost productivity, but this is what the lawyer says. As an employer, you have a legal responsibility to maintain a safe work environment for your employees. But as a human being, you have an even bigger responsibility to watch out for dangers to your employees that are regularly apparent. So the message is to think more. This positive approach requires thinking more broadly, moving beyond the legal frame, which focuses on the job injuries, to the bigger picture and the impact on your productivity. Just a quick what's going on in dispute resolution. We've been looking at discrete legal topics, but we could also look at this from a process perspective. And let me just give you 2 examples, and then we'll wrap things up. From a process perspective, here are the examples. You and I are well familiar with the process of mediation, which is an assisted negotiation designed to solve problems. In some mediations, the mediator acts as a facilitator. Sometimes the mediator provides an evaluation. But the more recent development is something called transformative mediation. And the goal of transformative mediation is to transform the relationship between the disputing parties. And basically, typically, one of the parties is more powerful. So transformative mediation empowers the weaker party and encourages communication. The U.S. Post Office adopted transformative mediation. They had 14,000 formal complaints with the EEOC, started this process. They resolved 17,000 informal disputes at a 30% drop in formal complaints, saved millions of dollars, and had a high satisfaction rate. I read a lot of studies of transformative mediation that gave facts and figures, but I wanted to put some flesh and blood on this. So I wrote to one of the researchers and said, give me an example. What really happens with transformative mediation? And she sent me this example. We've got female employee, petite, letter carrier, files a sexual harassment claim because her supervisor addresses her by her route number instead of by her name. In mediation, the parties realized he calls every letter carrier by their route number. He had no clue people found this dehumanizing or offensive. And that this was the real basis for the sexual harassment complaint. After this transforming experience, he started greeting people personally and apologized for the past conduct, and the employee withdrew the complaint. So transformative mediation is, I think, a positive element in dispute resolution. Let me give you this other example. This will be my last real example, but, and then we'll close. But a few years ago, the American Bar Association invited me to give a talk at one of their annual conferences. And they paired me with a guy named John Wade. And I was very honored to be with him because he's probably the leading mediation researcher and practitioner in the world. He's from Australia. And I was curious as to what he was going to say. So John, to illustrate one of his points, John gave this example of a mediation. He said he was mediating a divorce between a Chinese couple in Australia. The husband was a very prominent physician, very successful financially. The wife tried to start a business, wasn't very successful. They had a very bitter divorce proceeding, and they got down to the last $40,000. The wife basically said to the husband, I want $40,000 more from you. You'd already given her a substantial amount. He said, I'm not going to give it. So they brought in John to try to wrap this up. And John said to both of them, I want you to go off, talk with your friends if you want, but develop a list of your life goals. The wife said, okay. She went off and developed her list. The husband refused to do that. Again, he was prominent. He had a huge following in the community. The wife had very few friends. What I want you to do, just take 2 minutes here. If you were the doctor in this case, what life goals might you write down? You're a prominent physician in the Chinese community in Sydney. What might be your life goals? Just think of a couple. In the interest of time, normally I'd give you a little bit longer. Okay, let's just quickly. What's a life goal? Yeah, okay, to become an eligible bachelor. I wasn't thinking of that one. Okay. Give back to society. Life goal? Just give me one. Have a successful relationship, okay? After you finished your eligible bachelorhood, okay? Create a legacy, okay? Save face, good. continue as is your prominent position in the medical community. You want to keep your reputation. You want to continue your profession in helping people be healthy. Any others? Become even more prominent. You want to be a leader in the profession. Facilitate flourishing in every human organism. Okay? Let's talk about that after the session. Okay. He refused to do what you did. This is what happened. They finally split this remaining $40,000. They went to court. The doctor walked in with a huge throng of his friends. They were very jubilant. It was finally going to be over. He was going to be an eligible bachelor. The wife walked in with one or two friends. The judge announced the decision that it was all over. And the doctor and all of his friends, very hearty, walked out the courtroom, turned right, went to the most prominent restaurant in town to celebrate. The wife walked out the courtroom, and she walked past the husband's lawyer. And she turned to the lawyer, and she said, "Now it's payback time." She walked out the courtroom. She turned left, and she walked down to the offices of the local medical society. And she walked in, and she said, "Is this where I can file a complaint against a doctor?" And they said, "Yes." And she said, "Okay, I'd like to file a complaint against this doctor, her now ex-husband. Number one, he performed an illegal abortion on me. And number two, he has been sending drugs illegally to his relatives in China." She filed the complaint, completely destroyed his career, lost his medical license, lost his standing in the community, lost his income, lost everything. So, the message from this, as it relates to any of the dispute resolution processes, when you become involved in the dispute, step back, think of how this dispute relates to your life goals. I mean, he would have given her the $40,000. He would have given her a lot more if he had thought about the impact on his life goals. Okay, just to wrap this up, because I think it's time. This work that I've done relates to values creation as well. There's been a lot of work on corporate values. Lynn Payne of Harvard has noted the distinction between compliance strategies and integrity strategies. And people like Linda Trevino have looked at how companies integrate those strategies. One of the problems is both of these strategies are top-down, either lawyer-driven or management-driven. I think this positive approach has potential, and the top-down doesn't work for a variety of reasons. This positive approach has the potential to build values from bottom up. When you convert legal concerns to business concerns, instead of product liability, you're talking about developing products that meet customer needs. Instead of workers' comp, you're encouraging safety at work and at home. Contracting, focus on business goals and value creation. Workplace bullying, remove barriers that prevent employees from focusing on customer needs. Environmental regulation, and so on. So I think that this approach has the ability to develop a set of values that has greater sticking power than something that's lobbed out by senior management or lawyers. So, again, coming back to my question, I guess, does this proactive law model make sense? And might there be any glimmers of synergy? I know we're out of time probably to get into the details of that now, but I'd love to talk with those of you connected with POS and get feedback from anybody else on some of the things we've talked about today. And thank you very much for coming.